My name's Bruce Weber, and I'm the Dean of the Lerner College of Business and Economics here at the University of Delaware, a role I've been in for almost 12 years. And it's somewhat of a bittersweet time for me, as I've shared with some of our panelists, that this will be my final year as the Dean here, and I'm going to be moving to New York and taking on the role of the Dean at the Zicklin School of Business at Baruch College, which is part of the City University of New York. And if you know much about City University of New York, I think it's a university that's really benefiting the New York City community very much. It's a social mobility engine for the city, and I'm very excited to be moving into that role, even though the scale and the challenges will be different than here. They have it's 14,000 students total in the business school there versus about 4,000 here at Lerner College. So that's the role I play here at University of Delaware is to lead the Lerner College, and we have about 3,500 undergraduate students and about 1,000 graduate students. We make up about 20% of students at the University of Delaware. Right now, if you're a dean, we're in what's called yield period. So yield is when all the sons and daughters of many of you have applied to colleges. They've gotten their acceptance, and now they're deciding where they're going to go. So University of Delaware received almost 40,000 applications to be a first-year student with us in the fall. Our target is to have a first-year class of 4,200 joining us. We find out on May 1st what those 18-year-olds are going to be doing with their future, but we really hope they'll want to be blue hens, as 3 of the 5 panelists that you're going to hear from are. I won't disclose, but I can tell you the blue hen side of the panel is slightly towards me. These are the 60% of the panelists that are true blue hens here. And like me, Myron and Corinne made the mistake not to study here, but we're very happy to be here. So I'm tremendously grateful for the Weinberg Center, the role it plays in connecting the Lerner College to the Delaware legal community. It affords us many connections that enable our faculty and our students to gain access to an important part of the Delaware economy and actually the free enterprise and capital market system that we have in the United States. And I want to thank Louisa Cresson, Justin Klein, the director of the Weinberg Center, for continuing to lead this center in a way that benefits Lerner College and benefits the Delaware law community. University of Delaware truly aspires to be what the law community and the judiciary in Delaware are, which is, for the law community, a magnet for predictable and fair judging of corporate disputes, for the University of Delaware for high-quality education, demanding preparation, but in a supportive environment. So on behalf of the Lerner College, which hosts and is the home of the Weinberg Center, I welcome you all, and I look forward to a terrific event today. And I'll pass it off to my good colleague now, Justin Klein, the director of the Weinberg Center. Thank you, Justin. Thank you, Bruce.
Thank you, Dean Weber. I just have some short administrative announcements. To the extent that you would like to receive CLE, please sign in and sign out. Secondly, there are surveys on your tables. We would really appreciate your filling them out. They're enormously helpful for us. And finally, my colleague Louisa Cresson is in the back. To the extent that you have a question, please raise your hand and she will deliver to you a microphone. Thanks so much for coming. We really appreciate your presence and participation, and especially thanks to the Chief Justices here and to our moderators, Bill Lafferty and Corinne. So thanks so much.
Thank you.
I turn it over to Andy Bouchard, the chair of our advisory board.
Good morning. I want to start out, first of all, just to thank Bruce Weber. As he indicated, he's been the dean of the Lerner College for the past 12 years. This center is housed in that college, and Bruce, we are deeply appreciative of your support over the years, including some recent financial support, which I'm really appreciative for, and I just want to thank you on behalf of the center for those years of service. I'd also like to thank our moderators today, who I dragooned into service, and I very much appreciate that. We have Bill Lafferty and Corinne Amato that are going to be asking the questions today. They are two of the leading practitioners in corporate and commercial litigation in the state of Delaware. Interestingly enough, they typically are on opposite sides of the V, and maybe they'll bring some of that perspective to the conversation today. We're very fortunate to have our current and the prior two Chief Justices of the Delaware Supreme Court with us today. They together have served as the leader of the Delaware judiciary for the past 19 years, since 2004. They are part of a very exclusive group of people. They represent literally 1/3 of the 9 individuals who have served as Chief Justice in the entire 72-year history of the Delaware Supreme Court. A word on one of the other 9 members, who's the only other living member of the Supreme Court. I reached out to former Chief Justice Veazey. He's doing well, but he is living right now in North Carolina, at least most of the time, and sends his regrets. But he did send along an email with some comments, the same handwritten note I got to Jack that was addressed to Jack Markell on the attributes you want in a Chief Justice some 10 years ago. I think he sent it, or maybe longer than that. So we'll see if that has any effect on the process today. Article 4 of the Delaware Constitution provides that the Chief Justice, and I'll quote, shall have general, administrative, and supervisory powers over all the courts. Now, I emphasize, obviously, those words, all the courts, because that's really an awesome responsibility. The Chief Justice is, for all intents and purposes, the leader of the Delaware judiciary, the face of the Delaware court system, and a vital ambassador to the state of Delaware. And the responsibilities they have are truly vast. They include interacting with the governor and the legislature on issues that are critical to a well-functioning judicial system. That includes building courthouses. That includes paying people fairly in the judicial system. It includes maintaining and improving the technological infrastructure of what is a first-class judicial system. Some may say that's really just begging for money, and it is, but it's a vital part of what each of these individuals do or have done. It also includes, in their job description, serving as the administrator of 5 separate trial court systems in the state of Delaware, in conjunction with the Administrative Office of the Courts, or known in Delaware as AOC. They also supervise various arms of the court, the Board of Bar Examiners, the Commission on Continuing Legal Education, and many others. And they oversee disciplinary matters involving attorneys and, regrettably, on occasion, involving judicial officers. And, of course, they manage a 5-member appellate court that has the all-important final word on all matters of Delaware law. And they do it all while carrying a full caseload. I can attest to that personally. Now, in the realm of corporate governance, which is obviously the core subject matter of this center, the Court of Chancery, an institution near and dear to my heart, plays a unique role because corporate governance covers everything, or at least it covers everything on their docket, literally every day on a daily basis. By contrast, the scope of the Supreme Court's docket is far-ranging, extending from everything from criminal cases to personal injury disputes. Indeed, appeals from the corporate governance cases in the Court of Chancery really make up a relatively minor fraction of the Supreme Court's docket. But make no mistake, it would be impossible to overstate the Supreme Court's profound impact on corporate law as the ultimate arbiter of those issues in the leading corporate law jurisdiction in the country. Consider, for example, Schnell versus Chris-Craft, Zapata, Aronson, Rails, Tooley, and just recently Zuckerberg, Weinberger versus UOP, Smith versus Van Gorkum, Unical, Moran, Revlon, and McMillan, CD versus Technicolor, pick which appeal, I think there are 5 by my count, Time Warner, QVC, dare I say Omnicare, MFW, Corwin, Cornerstone, DFC, Dell, and Aruba, and the list goes on and on and on. The Delaware Supreme Court's impact on corporate law in the United States and the world is truly inestimable. And we are very fortunate today to have and to be able to hear from 3 of the most recent leaders of that court, who are all each very conscientious and able leaders, and we're proud to have them in the state of Delaware. Thank you. Thank you for coming, that is.
So let me get us kicked off really quickly. Andy did an amazing job introducing this panel, so I won't retread that territory, but I do want to make sure I frame up the timeline a little bit so we understand who was serving as Chief Justice at the important times when these amazing decisions were coming out that are now guiding our law today. Next to me is Myron Steele, and he served as Superior Court Judge and also Vice Chancellor before joining the court, the Delaware Supreme Court in 2000, and then became Chief Justice in 2004. We also have Leo Strine. We all know that he served as a Vice Chancellor for a number of years, elevated to Chancellor, then joined the Delaware Supreme Court as the Chief Justice in 2014, serving until 2019. And then we also have the Chief Justice as well, who joined the court in 2014 and then was elevated to Chief Justice in 2019. So, Bill, do you want to get us kicked off?
I sure do. And just normally I would refer to any judge as either judge or, in this case, Chief Justice. But if I use the phrase Chief Justice, I think they all three might answer. So I think I'm good. If it's okay with you, I may just call you CJ, Myron, and Leo, if that's all right. As Bruce hinted, 2 out of 3 of the former Chief Justices are graduates of this fine university. The third went to another state university. Myron is a UVA grad, but also is very tied in at having formerly chaired this organization. But to Leo and to CJ, what lessons did you learn here as an undergraduate that you've taken, I'd say, through life, and that you may have even applied in your time as being a leader of the court?
I mean, I think we both were influenced by some of the same people. I actually was, and I'll let you talk more to Dr. Souls, but I knew Jim Souls. I knew a guy named Joe Pica, who was my professor, and I think part of that department, when I was there, the political science department was very connected to the community, encouraged you to get involved. We're very bipartisan in the sense that people in the department, a friend of yours, Leighton Lord, for example, who was a Republican, was just the subject of mentorship by the people in the department to get them involved in public service. And so I think for me, it was also a place where I didn't come from folks who had a lot of academic experience or other things. It was a place where I could grow and get my footing and find mentorship. And so it was incredibly, and it was also wonderful. These people you stay connected to, and when Governor Carper became governor, Bill, and I'll finish with this, you know, Professor Pica got involved in the administration and essentially became chair of the State Board of Education. And so this kind of iterative thing, and some of the professors I met over the years, you get to work with them when you're a grown-up, and then, you know, people continue to pay it back. And so it was a very special place for me.
You can't overstate the role that Jim Souls had in many public servants' careers in Delaware. Vice Chancellor Fioravanti is a Jim Souls disciple, and I'm sure he would tell you one of the reasons that he wanted to be on the Court of Chancery was because of the lessons he learned from Professor Souls, that public service is, in fact, the highest calling and the most important thing you can do in a career. So once you've got your feet on the ground, as Leo said, and gotten settled and provided for your family, Jim Souls' advice was, do something for the public good, because it will be not only personally rewarding, but as important for society. He was a great influence on me. He was not my advisor. My advisor was a professor named Jim McGee, who is just the most lovely person in the whole world. And he took me under his wings or arms, and I was teetering on whether to go to law school or not, and he kind of pushed me over the edge instead of going into the Merchant Marine, and said, no, you need to go into law. And that started a lifelong relationship with him that I still treasure today.
Well, and CJ, if I may, like a point of personal privilege about, like, for both of us is Jim Souls when he ran for Congress as a president in 1974. His campaign manager was a guy named Ed Friel. His campaign treasurer was a guy named Tom Carper. Ed Friel, at the end of his career, has been just a wonderful, is almost like the inheritor of the Jim Soules tradition, and is a mentor of the chief of staff of the Department of Education, who's an amazing public servant and has a last name a lot like the Chief Justice.
It's my daughter.
When I was 18, Tom Carper, who was then, you know, I will always think of Tom Carper and Joe Biden as these dynamic young figures, because they were. Tom Carper ran for Congress for the first time, and there was an office on Main Street, and University of Delaware students, you know, kind of galvanized that office. The head of that office was a graduate student at the University of Delaware, Jeff Bullock, who was our Secretary of State. He was picked by Ed Friel, who was the campaign chief of staff. Jim Soules was, I believe, the campaign chair. And so all these people, but what I want to emphasize, I think CJ and I was, is we happen to be on the D side of the line. But these people all mentored, as Bill's a Republican, Bill knows that they mentored, it was the mentoring, the community involvement, that there's a larger vision about being a citizen, and what is common about our values as Americans far outweighs our political differences, and that building that kind of sense of community and what it means to be a larger member of a polity was really, I think, a wonderful strength of that department.
And Bill, we shouldn't short University of Virginia, because my father, a long-serving judge over 50 years, was a graduate of that fine institution, right, Myron?
That's correct.
And Myron, you've been in public service most of your life. I mean, between military service, Superior Court, Chancery, Supreme Court. What motivated you to go that route?
Well, the military is simple. My father was a career Army officer. Somebody in my family's been in an Army on this continent since 1657. So it's a military history that you're sort of imbued with it as you're growing up, particularly when you're never living in one place more than 3 years before you move to another. So it was impossible to say to my father, well, I'm going to go to Canada and smoke marijuana during Vietnam. It eliminated me as a candidate for president, and I understand that. But in fact, when I decided to go to the University of Virginia, every time I came home, my father would say to my mother, Colleen, the sorority sister's home. Why? Because I didn't go to VMI, the Citadel, where he went, or to West Point. So from that time on, I was the sorority sister in the family. So that
explains a lot, Myron.
It does. It does. It does.
I don't know that you're a handsome man, but you're not a really attractive sorority sister.
It didn't seem so. I didn't get a lot of dates when I was there. So in any event, on Jim Soules is no stranger to me. And you mentioned when he ran for Congress, that picking candidates in those days, I'm also a Democrat, at least still registered that way. And there was a vote of the Kent County delegation. Instead of voting with them, I voted for Jim Soules because I had met him, liked him, and he also had a degree, as the Chief Justice pointed out, from the University of Virginia. So we got to know each other well, and he's an admirable person in every respect. So I understand what you're saying when you suggest that he helped lead you to public service.
Let me ask this question, and I'll start with you, Myron, and I'd like to hear from all of you, really. But you know, public service, there's a lot of ways to serve the public, but taking on the role of Chief Justice is a very substantial role. Can you just give us a little bit of background on what motivated you to take that position and how you landed there, and what sort of led you to become the Chief Justice?
Well, this is going to sound cynical, but 18 years as a litigator, you see things in the system that you would like to change. And the only way you can make the change is to get in with the system, learn it, work with other people, learn from them, and then with a little bit of dash of political savvy, I'd like to think, you move up the chairs as best you can in order to make the changes, if you can, that you'd like to see happen, and try to influence people in that direction. Sometimes you are successful, sometimes you are not. But the motivation was to see how the system works. I think it's like any piece of machinery. If you see how it works, understand what it's supposed to accomplish, you want to tinker with it to make it get there more efficiently, less expensively, and with greater availability to those that want to use that tool. So that may sound trite, but that's my answer. By the way, this is like Jeopardy, because I have no idea what I'm being asked. So you can't put much stock in the answers as a result.
Well, is there a particular change that you're thinking of that you felt like, after your years on the court, you saw something that needed fixing and you felt like you were able to make that change?
Actually, irrespective of the article of the Delaware Constitution, I saw historically where there were some past Chief Justices that would start every letter with, under Article 4, I am the administrative head of all of the courts, and that wasn't my style. I didn't believe in top-down management. So my job, as I saw it, was to get the resources and give assistance to the chief judges, president judge, chancellor, chief judges of the other courts, make sure they had the resources they need to get the job done. And if there was a problem, try to help them solve it. But otherwise, the quality of the judiciary when I was there didn't lead me to think that I need to beat people in the back of the head and say, I am the administrative head of all of the courts. This is the way we're going to do business. That wasn't my style.
Yeah.
So there's not much change that I affected from the law. The two most important goals I had, I was successful in one and unsuccessful in the other. First, I wanted to eliminate and kill for all time the onerous triad of fiduciary duties: duty of loyalty, duty of care, and then that bone that our, unfortunately, 102B7 gave to the academy to try to create this good faith concept. And the academy tried to write into it a kind of reckless standard, as if we had torts all over again: intentional, reckless, negligence. The academy wanted to create this basis for liability based on conduct that could be characterized as reckless. And I think most people at the time would agree, most Delaware lawyers, I'm the only people that I really care about at the end of the day other than family, thought that it was probably a good idea not to have that slippery slope of anybody make whatever they want to make out of the concept of good faith in order to get the result they want. So in Stone versus Ritter, we were finally able, in a 5-0 opinion, to get rid of good faith as a separate, independent fiduciary duty. That's not to say that good faith can't be discussed, but how many cases do you read over the years defining good faith? Good faith is the absence of bad faith. What? I never found that very helpful. And that's what most of the older cases suggest. Good faith is a nice tool for equitable analysis, but it shouldn't be a freestanding, independent, allowing the academy to wrap their own definition around it concept in order to increase liability. So that was number one. Number two, and this will get a rise out of maybe a former Chief Justice who's with us, because this is a war he won and I lost. And that's the alternative entity statute concept, particularly LLCs, where I believed and still believe, although I concede, you fight wars, some you lose, that the default position in a statute that says maximization of freedom of contract is the policy behind this statute. The concept that the default position in the absence of discussing fiduciary duties in an LLC agreement should be there are no fiduciary duties. Lost that. Lost it the fair way. Better opinion was written about it than my LLM thesis, which was on that point. It's now under somebody's trash can in every law library in the country because it's no longer relevant. But that was what I tried to do on two points. And then if it hadn't been for my dissent in Omnicare, I probably never would have been Chief Justice. So those are the three cases that I remember.
Is Omnicare still a thing?
It hasn't been reversed. To my knowledge, there hasn't been an occasion to do so. And people work around it.
Leo, did you want to respond to any of that?
No, because I don't really think I have a doctor. I mean, I mean, I can sort of blend it in, Corinne, if it makes sense to you, with
Yes.
why I wanted to be
Sure.
Chief Justice. I was lucky enough. Look, I was privileged. I mean, part of the state gave me the opportunity. I became counsel to the governor of the state, the first Democratic governor of the state, if you think about that historically, in 16 years. And I left Skadden to do that. And I've been privileged to be involved in protecting my state. I mean, I helped negotiate the settlement in Delaware versus New York and do things like that. But I've known how important all along the privilege we have in entity law. And one of the things I was fortunate to as governor, Governor Carper was a full partner with the judiciary in a way, honestly. I love all governors. But I mean, he actually, the court's 2000 initiative, Chief, was an executive order crafted with the judiciary, and I got to work with Chief Justice Veazey, and Justice Welch was his point person, with Rod Ward, my dear friend who we lost, and Frank Biondi. And the administration really worked together to improve, like, a lot of the things that you see in the Superior Court, like the commissioners and other things to help them with their caseload came out of that, other resources. So it's always been, you know, this is a special institution, and I got to work. You know, my reason for being Chancellor and Chief Justice was sort of, there were two reasons. One was that two people I loved decided to move on. One was Bill Chandler and one was Myron Steele. And honestly, after doing the job, I mean, it was more, I didn't want either of them to leave, and I was privileged to work with them. But I did think, because I was privileged to help my chief, both my chiefs, Chief Justice Veazey and Chief Justice Steele, help Chancellor Chandler. Like, we got rid of the Register and Chancery elected system when I was there. I mean, imagine that we had 3 elective bodies next to the Court of Chancery, and we worked together to get that done. There are things like, and I'm proud to be part of a lineage. I think is things like, do you know when you make $35,000 a year, that's $1,700 in post-tax dollars is pretty important to you? Would you agree with that? And would you agree that people should be paid equally? Well, people thought I had an obsession with parking. It wasn't an obsession with parking. Our Newcastle County court staff didn't get free parking. And they live where they have to pay the city wage tax. And we fought and we got that done. Working to get the family courthouses in Kent County and Sussex County, both the chiefs know that that's not safe and fair. And it spans the 3 of our tenures, right, Myron? And I'm so proud that the chief is pushing them on. So it's issues like that, and, like, to me, in my mind, passionate about inequality in our state, and the fact that judiciary gets tagged, right, when it looks like the number of defendants who come before the court are disproportionately black in comparison to the population. Well, a lot of inequality starts from ground zero in poverty and school inequality. And for the judiciary, and Chief Justice Steele had focused on this with the equal, justice, to try to do our part to make it equal. Those are the things that animate you. But we're here to talk about business law. And I'll get back to why I don't want to fight with Myron, because I don't actually think we have a fight. Because the interstitial thing we have about alternative entities is less animating than, I think, our commitment to the larger Delaware vision, which is in the area of corporate law, the business judgment rule. And the idea that when impartial fiduciaries or the disinterested stockholders get their say, that the courts stay hands off, because that's what's best for the system. That you respect that you're judges, that you're not business people. That Coca-Cola, this will date myself, but for young people, the new Coke was a disaster. If you had had a monetary damage against the new Coke because people had made a bad decision, then you wouldn't have had all the innovation that's come since and the value. And that the,
I mean, there's a better Coke now?
I don't know. I mean, well, there's one, the illegal one, but the Bill, a dear friend of mine, and we also lost, Bill Allen, and I would talk about this a lot, Myron, is trying to not forget as waves of innovation come, that there's a tradition in Delaware law, and that you adapt the tradition to the circumstances, but you don't lose sight of it. That we are not an inquisitorial system. That what we try to do is set up good incentive systems that are predictable. And sometimes those things will go wrong, but on balance, when you encourage that kind of decision-making, Corinne, which is to empower the independent directors, to empower the disinterested stockholders, to have a balance, to respect the fact that judges should adhere to the case-by-case method, that the Delaware General Assembly could not be more attentive to the corporate law, and so there's very little need for the judiciary to come up with bright line rules that could easily be in the DGCL. And so to the extent I got to follow my friend, and because he left, I viewed it as continuing this project that Bill Allen and I had talked about, of which getting rid of the triad, as you know, Myron, was part of it. But understanding that things like, people will tell me, I'll finish on this, people tell me Corwin is novel. And I'll say, really? Did you ever read the whole case of Van Gorkum? You ever heard of anybody in class, have you heard of Van Gorkum? What's the last section of the Van Gorkum opinion? It's about disclosure. And you know why it's in there? Because absent a disclosure claim, all the stuff at the front was dictum because it was business judgment rule. You go back, compensation cases. Did you have to have all this elaboration? No. If you had independent decision makers, then it was business judgment rule. There are old cases. There are books. And part of what I viewed myself as doing, I think Myron did, was as long as if we're encouraging impartial decision making, things that are of high integrity, expecting people to do it, then we should try to be more reticent. And I think what we both tried to do a little bit was to create those pathways. And also, frankly, then, I gave some really big fees. Probably nobody gave like bigger judgments than me in some of them, right? But not reward, and this is where I see Chancellor Bouchard, not reward the things we were trying to do in the area, like not give fees for no achievement, because that doesn't help stockholders. So on the business law thing, that was sort of, Corinne, what I viewed my project as, but it wasn't limited to the Supreme Court, but it was sort of a continuation, honestly, of a tradition I very much learned from people like Bill Allen and Jack Jacobs, and when I was on Chancery.
Was that something you talked about with Myron before making the switch into the role of Chief Justice? Did you have sort of a conversation about where the doctrine was going and where it should go?
I think one of the strengths of Myron all along, and I hope all three of us, is approachability and being willing to listen. I mean, one of the things that I get the most out of conferences is talking to the transactional lawyers, the ones who don't go to court, because they're much more willing to say things to you that you kind of need to hear. And I used to, every year, it was a 20-year tradition. I've actually continued with Chancellor Bouchard, and I got members of the current Court of Chancery involved, as I would go up and have the New York City Bar Association every December. And it would be a big room, and they would, like, when Rural Metro came out, some of them had, like, anti-Rural Metro hats. But they would tell me everything, and then, you know, frankly, Myron would encourage me when Bill Chandler was Chancellor of Myron Supreme Court. I would come back and say, here's what I heard. He would do the same with me. And so I can't say that we're always perfect at all. That's not, and that's also important to be a judge, which is to understand that only one thing might be perfect and omniscient, and it ain't you. But I do think that my two friends here, I won't speak for me, but I tried, I can't say I succeeded, is we try to listen and to talk to each other and not blindside each other. And as I said, on things like the alternative entity thing, I never viewed it as, I don't view that our differences are that big, and I view our larger vision of predictability, but also high integrity. Like when we say, Corinne, we say a special committee, we mean that it's doing things the right way, that there really is disclosure when there's a vote. But I think the communication was one of the biggest, and remains, if we do it and commit to it, one of the biggest strengths of our bar and bench.
Oh, absolutely.
I suspect most people want to hear from the Chief Justice.
Yes.
I was going to say.
Yes.
I have just one more thing to say about the relationship that was just described. As a septuagenarian, I can remember what was profiled by some as tension between the Delaware Supreme Court and Chancery. And one thing I didn't want to have anything to do with was renewing that kind of Justice Moore, Chancellor Allen perceived disconnect. And that, if I wanted to know where Leo stood, and I say this tongue in cheek, all I needed to do was read the footnotes first, then I knew where he wanted the law to go. So I could be helpful in that way, and I couldn't have had, during my tenure, a better chancellor than Leo. We both had the same goal, and that is, as he has stated, to keep Delaware on track and make us still and forever the place people wanted to charter, no matter what form of entity. So that's...
CJ, you took over as Chief Justice in late 2019, right? Right before something called COVID struck. And I'm kind of curious what's your perspective, having led the court through the last couple of years, but also just sort of, did you come in with an agenda or a list of things that you wanted to try to achieve as Chief Justice, and did that upset the apple cart? Like, and do you think the courts are back on track to where you want them to be?
I hope I'm not perceived as coming in with an agenda, because I really did not. One important thing to emphasize what Leo and Myron said is, I mean, Leo and I were serving on the court together for years, so we were pretty simpatico on most things. I mean, God bless Leo trying to get criminal justice reform through and revising the criminal code. Didn't happen. Pieces of it happened, but it didn't happen. But you know what? He kept banging away at it, and it's now the platform for discussions on how we might do that in the future. I mean, there were a lot of incredible things Leo did and Myron did. So it was, you know, I viewed my role as starting to build on some of the things that they did. And then, of course, COVID hit, and it turned everything upside down. The one thing I'm most proud of during COVID in the judicial branch is we did not have anybody die from exposure in any of our courthouses. I mean, really, and that's what I said to my staff right out of the box. He said, we do not want to put our employees at risk. We don't want lawyers to be at risk or judges to be at risk. And we were successful in that because we had a judicious plan to take it slow and be careful. We hired a doctor, Alfred Bacon, who's the chief of infectious disease at Christiana, who advised us at every step. We had a call with him every week, and he said, go with this, don't go with that. And it was incredibly valuable. And I like to say that unlike a lot of other court systems that closed, I mean, the New York courts closed for months, and they're paying the price for that. We shut the courthouse doors, but we did not close. And the magic was that we hired Justice Breyer's son, whose company is called Court Scribes. And they did all of the back office for all of the Zoom that took place for the judiciary. And it was a lifesaver. The Court of Chancery transitioned to Zoom hearing. It was the best they could do. The Supreme Court went to Zoom arguments. And we soldiered on. That's not to say everything was perfect. The high volume courts are still digging out from under just a backbreaking load of cases that piled up during COVID. But I have to say, I think the Court of Chancery especially made the state of Delaware proud, because a lot of these busted deal cases and other important cases continued on even despite the pandemic.
Yeah, and Chief, I just wanted to say, I know from my transition and from having things that were both in, being involved in things that were both in Delaware and other places, that the outcome of disputes was materially different in Delaware than in other places. And even when cases didn't get to adjudication, the availability of the court, allowed them to be resolved on the merits. And a lot of other places, Chief, you and Chancellor Bouchard and all of you should be proud, a lot of them were resolved on kind of non-merits basis, simply because, as we all know, especially in commercial disputes, somebody who wants delay can benefit from it. And the unavailability of the courts drove outcomes, and that was never the case here, and I hope you feel as proud as you should about that.
So let's talk a little bit about doctrine. I know Myron had mentioned Stone v. Ritter, but I'm going to throw it out to you, Chief Justice, first. CJ, Chief Justice. Doctrinally, what developments have happened on your watch and that are maybe you're most proud of in the corporate area?
Well, I think that you can't answer the question without talking about what the trend in cases has been. Thanks to Myron and Leo, they worked out some of the inefficiencies. Not that they're all gone, but they worked out some of the major ones. I know Leo says Corwin was no big deal, but guess what? It was a real big deal. Certainly to transaction planners, it was a big deal, as was MFW. Leo worked a lot of the inefficiencies out of our system, which made the Supreme Court's job easier. But as Myron knows, because he was the king of MLP cases, we still have a ton of bespoke contract interpretation cases coming from the Court of Chancery because of Section 111 and other alternative entity statutes and the jurisdiction that goes along with them. So now, I would say a lot of our diet is interpreting agreements. It's incredible, that shift. And as with all language, it's imprecise. There's room for disagreement about what the words mean. You'll see that sometimes, among my colleagues when we don't always agree upon something, even though we're all confident that there's only one reasonable reading of the contract. But that's really been, I would say, the reflection of what our court has been doing, writing these opinions about bespoke agreements involving hundreds of millions of dollars. And the Court of Chancery does their best to figure it out. We do too, recognizing that in many ways transaction lawyers agree to leave differences in the negotiations to a later day in the hope that maybe it won't come up. But if it does, the courts will solve their problem in something that they were unable to negotiate clearly.
And Chief, you mentioned 111 and jurisdiction and how the Supreme Court's seeing a lot of these cases. I take it that the Chancery Court has also been inundated with these contract commercial disputes, some of which arise out of merger agreements, some are other transaction agreements. There's a new initiative, as I understand it, coming out of your office and in conjunction with the Chancellor. Do you want to talk about that a little bit in terms of how those cases are going to get handled in the future?
Sure. So here's an example. For those of you that might not be familiar, I entered an order after discussing it with the Chancellor and the Court of Chancery, which allowed the President Judge of the Superior Court and the Chancellor to confer and balance some of the cases that are filed in the Court of Chancery that essentially are breach of contract cases. Here's an example. The very first case that was transferred under that order, they were seeking $270,000 in damages. And it was a pure breach of contract case, and that one seemed ripe to be decided by the judges in the CCLD, in the Superior Court. Those are the kind of things, we're trying to rebalance the work of these two courts where we have fully capable judges in the Superior Court and the CCLD that can decide breach of contract cases. It's not a major shift. We're just trying to balance better the Court of Chancery's docket to give them some assistance in some of these cases, which, if you look at the docket sheet every day, there are 7 to 8 new cases filed every day in the Court of Chancery. So this rebalancing will help them manage their workload better.
Yeah, maybe if we could go turn back the clock, we wouldn't have expanded 111 quite as far as we did.
Well, it's
maybe
been
10
very-
years ago. I don't know.
Look, Bill, it's been very good to the state, and it's been very important to the Court of Chancery. These are not, some of these are not small disputes under 111. They're quite large, and if you can get a, chancellor in a non-jury trial in a big case, isn't that part of Delaware's brand? I mean, it really is, and that's, I think, Myron would tell you, that was kind of the reason for 111, is that bring the Court of Chancery's expertise to some of these merger-related cases, and it was very important to the Court of Chancery and to the state, because look at, alternative entities in the state and where we are compared to other jurisdictions. It's amazing.
It's also, right, Chief, one of the things that I always joke with somebody, we'll do a 2-volume history of great cases in Delaware commercial law. I'll do volume 1, and it's the hard work. I'll do 1789 to 1990. Myron, can you do 1990 to 2023? The reality is, we went through shifts like Delaware's own core fiduciary duty stuff is much bigger than it would have been in 1975. When I grew up, everybody asked where they worked at DuPont, Hercules, or whatever, or, maybe the bank. That became bigger. Then you get bankruptcy. Then because of Delaware actually solidifies it, the IP stuff becomes big. But really, it's commercial law. If you think about things like, I remember the worldwide wrestling case that Bill Chandler had, or I had, IBP Tyson. If you go back, that wasn't how people used Delaware. And it's become a big part of our brand. But it's document intensive, as you know, it's trial intensive, and that puts a burden on both levels of the court in a way that is different.
Let me ask this. So, Myron, when you were Chief Justice, the CCLD was actually formed at that point. Would you have expected or anticipated there would have been collaboration among the courts with respect to these contractual type issues at that time?
I wouldn't have expected it in, let's say, 2004 to 2010. Probably wouldn't have been clever enough to think about it myself when I was there. I don't think the intensity of the work in Chancery was exactly the same at that stage. And if I have the numbers correctly, I think that it was 2004 actually that suddenly the alternative entity sphere, particularly with LLCs and to some lesser extent MLPs, but all the letter variations on private non-corporate business entities just exploded. And that's really important for Delaware, because one of the things all the chiefs have to do, in my view, is keep an eye on where we are nationally and what we need to do, along with the corporate committee of the bar and the assistance of the General Assembly, to make sure we're 3 or 4 steps ahead, not 3 steps and 2 steps back, although that worked pretty well in China in the 1940s, but I don't think it works that well for us today. And if indeed there is one day a statute that's been introduced that's passed by Congress that nationalizes basically publicly traded corporations of a certain size, we'll lose a substantial portion of the governance of those entities. So we have to keep our eye on that, and enhancing our situation as a place where alternative entities are comfortable is tremendously important going ahead in the future. We also have to keep an eye on what other states do. I don't remember when I was more mortified than I learned that Nevada had taken 102B7 and stretched it to include the duty of loyalty. So you could be exculpated as a director for a breach of the duty of loyalty. I had the occasion to go to a conference in Nevada and debate with some of the Nevada lawyers who were advocating for that. And I said, keep one thing in mind. You can only go so far, to take Leo's characterization early on, which I've never forgotten. You get too far out of your lane, and that tractor trailer that comes out of D.C. is going to flatten your ass right on the highway. And as soon as there are certain people in Congress who see that you have exculpated for duty of loyalty, and you actually are successful because they're investors who are stupid enough to charter in your state, then you're costing all of us jurisdiction over those kinds of issues. So the chiefs have to keep their eye on what's going on around the country, too, that might jeopardize our position.
Has there been much talk about the sort of federal intervention of late in the circles that you travel in?
You know, Leo and I were at the Securities Law Regulation Institute conference in January, and we've crossed paths at other things, and Ted Yu has been on a lot of these panels, and I had a conversation with him where he said, you guys are doing great. Everybody's staying in their own lane. You know, we have confidence in Delaware. We got universal proxy, but we're not going to invade Delaware space in that. We think that Delaware law has got that handled appropriately. So my view right now, as Myron says, you always have to be on guard. But my view is that things are not threatening right now, except for around the edges a little bit with some of the scandals going on.
I think we always have to be on our toes. I think the SEC has been a good partner. I regularly interact with them still, and I love their staff, and the professional staff are a joy to work with. But we have to watch overreaching. As someone who, you know, every time I hear somebody point to what we got in this sheet as a windfall, what Governor Carper did, that was a matter of federal common law, and there was more sponsors in that Congress to take away the victory than on any other bill. And that diffused things, and we've lived off that. If we overreach, and there was just a case in the U.S. Supreme Court, so I'm not disclosing any secrets, that Delaware lost. Well, we're losing as people used to want to pay us taxes because we're the most reasonable. We need to remember that. And as Myron said about integrity, our brand is integrity. We've all been able to defend our brand because we can point to situations like I always say, look at all the other 49 states combined, and you give me a list of fiduciary duty cases where people have been held accountable as they were in Delaware in these cases. We are not the bottom. We have to please everybody. But if we worry about there have been issues in trusts and estates that we've had to diffuse where people, one was a convicted fraudster. He had been barred from serving a thing. He appointed his sole asset of a Delaware LLC that was put into trust was one of his personal residences. And the trust protector resigned and wouldn't defend the litigation because they were only getting paid $3,000. This is in the Washington area where there's the Washington Post. The amount, right, if we're getting $3,000 and the person who's getting it, that's not employing real jobs in Delaware, and our reputational harm, they won't cabinet what I'm saying to trust and estates. They won't cabin this stuff. And as Myron said, it's a matter of, in our federal system, interstate commerce, it's very clear that the Congress could say something like Myron said. And I think the three of us and all the members of Chancery and the Supreme Court over the years have tried to encourage us to have a system that we can all be proud of, that's a high integrity system. I said, I stand behind the business judgment rule and all that kind of stuff, but what comes with it, as Myron said, is this strict enforcement of the duty of loyalty, the idea that there is integrity to the system. That's, in my view, essential to our durability. And it's when we overreach and we compromise our integrity that we maximize the chances of federal intervention to the detriment of our community.
So, Leo, Myron, I have a question for you. In my opinion, some of the hardest cases to decide are director independence cases. Did you find the same thing during your watch? The calls are so close, they're so fact intensive, and I really sympathize with the Delaware Court of Chancery who is making these calls where every situation is different and could be reviewed differently on appeal.
Do you want to go first?
Just two cases that bring that to mind. Martha Stewart, I thought, was a very difficult case on the very point that you make. Could have gone either way. I think it went the sensible way at the end of the day, but probably I would. The second thing is I remember Stanford Red, for the too much Stanford Red on the independent committee. You've got to keep an eye on that because of the very point you made, Leo, and that is the integrity of our decisions are more important than how they're written or how long they are or how many footnotes there are chastising the Supreme Court. Oh, sorry.
Well, no, but I was going to say one of the things that comes with if you're going to set up, if you're going to give credit to having a majority of independent directors, like one thing, the old school, by the way, you don't have to have a special committee. Read the old school. There's 3 ways to get business judgment rule in a conflict transaction. Vote of the non-conflicted stockholders, majority independent board, or special committee. If you're going to defer, especially if you're going to gate cases on a motion to dismiss, right, on that basis, Chief, then you have to be pretty scrupulous about what independence is. Delaware has always had a real-world view of things. One of the things that has drawn, I think, the 3 of us together is I think we're pretty loyal friends. And like, he and I have had some of the biggest tussles over the years. I love him. And he is so special to my family because he, no, but he seriously, like, he did something for my family we've never forgotten in terms of my 8-year-old son's birthday and a dog. And he and I have, and those of you who are fortunate enough to be Myron's friends know, I see Mark out there, that it's a full-bodied relationship, right? And so when you don't forget that when you come into looking at independence. And so I think there's actually pretty good guideposts, Chiefs. And I guess what I'd say is I'd rather fault the Court of Chancery for saying in a close call about independence that I'm not, at the pleading stage, I'm going to find a non-independent, and we get there. Then they have a situation where you've got clearly a fully independent board, but we're not giving credit to that, and we're having over-elaborate things, and we're saying, well, but you have to have both this, you have to have a stockholder vote, and the statute doesn't even call for a stockholder vote in order to get the business judgment rule. I'd rather the fault line be on the independence rule, encourage that. It's pretty easy to have a subset of directors, and I would say those of you who represent companies, gives you a strong hand. Blake, you should be able to go to companies and say, you should have at least 3 or 4 directors about whom there's no reasonable question. And when it comes before the Court of Chancery, that it doesn't put them or the Supreme Court in some way. I'd rather have that be the fault line, Bill and Corinne, than on whether the safe harbors are actually reliable that have traditionally been the guidepost for good advice.
Yeah, and I think, if I recall, Chief Leo, you may have come up with a catchy phrase in one of the opinions. I think it may have been Sanchez Energy, where it has to be friendship plus, right? It's not,
Yeah.
you know, it's all degrees, right? Because it could be a friendship from kindergarten through, you know, for 50 years, maybe different, maybe through alumni, through college, you know, but there needs to be some other financial component to the relationship to sort of get it over the hump in terms of finding
Right, and that's why I
lack
think
of
these
independence.
cases actually cohere with Martha Stewart, because the whole point of just that you went to a few weddings together, or I think is very different than if, for example, for the last 10 years, for each week of summer, the 2 families vacation together, you know, and the siblings, it's an intergenerational thing. I don't think that was anything like in Martha Stewart, but you have to ask yourself, those of you who counsel businesses, the 2 most suspicious people in all about other people in the world are doctors, and then the other is business people. And when they deal with other companies and they look at a situation, they always think that it's fraught with conflicts and things. Well, this is a system about integrity. And the idea is, if you're using these independent directors, right, Bill, as a cleansing mechanism, so that you're not going to adjudicate the merits, right? The court is going to step back and say, those 3 people decided. Can we have in Delaware a system where if there's a reasonable question about whether they really are impartial, that we're going to just you know, kind of dismiss the case and leave it unadjudicated? I think that it's a better incentive to say, yeah, we actually are going to be pretty realistic about human beings. We're going to do Martha Stewart because we're not going to just let you say that they went to a couple weddings together or something like that. But if it really looks like they have been fraternity brothers forever, that one of them introduced the other to his wife, that they own a plane together, that we're not going to be doofuses. Remember, we lost the great Jim Neighbors associated with Gomer Pyle. It is not good for Delaware if we look for like Gomer Pyle. It's not credible to those of you like Corinne, and I see your partner Mike, who do the hard work of plaintiff's work, which is essential, if we're not being realistic about these things.
One thing that I think may be interesting for the chief going forward is the fallout from this SVP bank, when you have a board that's so independent, they know nothing about the business. They're there to help manage, in a sense, or at least supervise the management. The pendulum swings a lot when you're 77 years old and 53 years of practice. That's the pendulum to watch right now. Maybe there are too many independent directors who don't have enough knowledge of what they're supposed to be doing, but have great credentials. They went to the right schools. They give the board diversity in various ways, but they don't know anything about the business. And you have a problem. Maybe there's a new balancing coming forward.
You and I agree on that. That's why I think the enough factor, which is have enough of the independents, Myron, so that when it comes to the work of a special committee, but that doesn't mean your board should be driven by people who don't have industry expertise. And I think the feds have actually been more problematic than Delaware on having that switch that just flipped between non-independent or other. I think we look at it situationally, and there are many situations where, frankly, a management director is not, in my view, conflicted if it's not a conflict. But I think when we get into the harder cases where you're gating a derivative case or you're dealing with a transaction that's a conflict of interest, I guess what I'm saying is sort of shame on the controller or the board if you can't have 3 or 4 people that you can put before Chancery where there's just no reasonable question about it. I think that's the better place for Delaware to be, and I don't think we should apologize for being given the deference, the very deference we give under the business judgment rule, that we shouldn't apologize for being fairly tough on independence.
Corinne, did you want? So, Myron, you mentioned SVB. It's a good segue into talking a little bit about it. It sounds to me like you're thinking in your mind, is there a Caremark issue arising out of some of the things that happened there? And it made me think, we've seen a lot of Caremark type cases come out of the Delaware courts over the last few years. I wonder whether you have a view on the direction of those cases and just sort of whether we're in the right space and whether they're going the right way.
I haven't reconciled in my own mind, not that that's important anymore, the difference between Caremark being a duty of loyalty and a duty of care, or some mix of the two, like the original egg for another species altogether. And with SVP, one of the major failures there, one could argue, is the failure of federal oversight, which is supposed to be, the answer to everything. I mean, when I was growing up, if you wanted to solve a problem, you either felonized it or federalized it, and then the problem would go away, right? Once people knew the crime was a felony, they'd never commit that crime again because the consequences would be too great. That's silliness, and maybe it's silliness to even state it, but there's a lot of that kind of dull thinking around that. Where the duty of, so-called duty of oversight is going to go, I prefer to think of it as Caremark and not a duty of oversight, because that's sort of like good faith. It's sort of very malleable. It's hard to get your arms around it. You can make it whatever you want it to make it. I'm not sure where it's going to go. I was comfortable with Bill Allen's construct, which I read, of course, conservatively, to mean you have some kind of duty outside the boardroom itself that's imposed upon you because your product is regulated. There are safety issues that are inherent with the product and its manufacture. You have to be tuned in to have a system in place to catch red flags and then act on the red flags. I'm comfortable with that. Beyond that, it's hard for me to get there, imposing liability beyond that.
I don't know what, Leo, whether you have any other take
I
that you wanna
viewed,
share
I
on
mean,
that.
to the extent I was involved in this at the end, I actually have the view, I think Bill Allen, and I've written about this, I know that Bill 102B7ized Caremark from the beginning. He never liked Van Gorkum. So he sent the liability bar. Remember, good faith, one of the weird things one of the things I agree with Myron is good faith is the test. That's the state of mind of a loyal fiduciary. So it was tautological when you did the two things separate. And if you read the Bill Allen's cases, and there's an article I did with Larry Hammermesh and Jeff Gorris about this, is Bill Allen set the liability standard at a scienter-based level so there wouldn't be overuse. We had a case involving an ice cream company. He did say there have to be some efforts. And what Bill and I used to talk about is basically is there evidence you made a good faith effort to try to do this? We had a case where there was no committee, no reports, nothing about ice cream safety, and the only thing the company made was ice cream. I think there's been some Court of Chancery rulings similar, like products that can actually, if they don't work, hurt people, where books and records can be your greatest help here. If you have good books and records, the better plaintiffs won't even bring the cases. But when you produce 2,500 pages of documents to Corinne, and you have a monoline company, and there is no board committee set up to deal with the safety of that product, there are no minutes dealing with that, and there are red flags. Again, I think it gets back, Myron, to your point about integrity, is as hard a standard there is under Caremark, there have to be some cases that go forward. And I would say that even in this wave, and it's not the newest wave, because at the end of the 90s, you know this, Bill, there was federal cases under Caremark where people got loosey-goosey, and federal courts had sustained Caremark complaints, and people get more careful. I think the trend of the cases overall is still dismissal. But those few cases that go forward are actually a reminder that there is integrity to this standard that Bill Allen set up, and that helps the better angels of your nature, win out in the boardrooms. And so I don't think I think it would be a worry, honestly, if there was no situation in which Delaware actually applied the standard, Corinne, that was set up in Caremark. I think that would be a far worse standard because it would look hollow, because it would be.
So, well, I guess it begs the question, does that Caremark standard shift with the times, right? Because
yeah, but what's the time? I mean, I think the issue is, and it was set up to be elastic, is it cannot be that every minor violation of law by a big entity with 40,000 employees and multiple generations gives rise to a Caremark complaint. But I believe that the courts have done a good job of gating it. But if you look at again, I don't want to use the company name, but there's the chancellor, there's a big ruling by the Court of Chancery in a huge company case involving a product that couldn't be more sensitive in terms of human life. The idea that the board of directors should not be attentive to the central safety risk of its central product line, I think that's what Caremark was about. If you're going to get to, the law professors, I always love Myron, come up with the traffic, what Myron and I would say, because we're both kind of criminal law, we like criminal, the malum and prohibitum sort of stuff, where the FedEx truck was parked for a little bit longer, Chief, to deliver the package. And is that going to be a Caremark claim? No, it's not going to survive. And I remember, didn't we have a case about even companies having to navigate regulatory things in other markets where we...
But Lee, how do you square some of the case law that says you have to show intentional conduct or bad faith to jump over the bar?
I think I think there's two things, right? One is the cases of intentionally violating the law. And I think, I don't really separate. I think Bill Allen was dealing with it.
They're easy.
No, but that's long. You cannot profit under Delaware law by intentionally violating law. But the other is, you have a duty under Caremark, to try to have a reasonable monitoring system. If it turns out at the end there was no board monitoring system, there's no reporting violations, there's no action on it, then you do, as part of your duty of loyalty, remember the duty of care, in my view, is subsidiary. A loyal fiduciary tries to act with care. Family lawyers, the concept of neglect. It's not simple negligence, right? Is those of you who've been a CASA or something like that, or a guardian ad litem. Neglect as a parent is when you have you have a duty to be a parent, that over time you consciously fail to fulfill that. That's how I look at this, Chief, is that the plaintiffs have proven to the court that essentially the directors have failed the mirror test, and they can't even honestly say to themselves that they made a good faith effort to try. And if they're held liable in that circumstance, because they are, for Myron, as you know, they're put on the boards as monitors. That's part of why these independent directors exist. And if you can't, on a central business risk, show that you actually had a board structure that took it into reasonable account, I guess I got to say that I think it's better for Delaware to hold people accountable in those rare situations. And I think the Court of Chancery still in the main, you are much more likely to get a Caremark case dismissed in the Court of Chancery than to get pass go.
Because the reality is these cases live or die at the motion to dismiss.
Yeah,
frankly.
yes, and what I'm saying about writing the play is with the ubiquitous use of books and records here, if you have attended to the risk, if it is in your risk management structure and there are reports and you turn it over to the better plaintiff's lawyers, they actually don't even bring the case. And you're able to, it's the absence of effort that gets people to pass the motion to dismiss, because if you have to make a good faith effort to try, then the most compelling evidence of a failure to try is that you produced all the key books and records and the evidence of your efforts is wholly lacking.
Which did you like better, the Court of Chancery or the Supreme Court?
You're not really asking me that. I'm not really answering it.
Can I ask?
It's easy.
Let me. Can I take you? I want to ask you another question, because obviously two of you served on the Court of Chancery, and I think somebody mentioned at the outset that the percentage of appeals where the Supreme Court overturns a decision of the Court of Chancery is low. I mean, it's in
Our reversal rate is
single digits.
Of all cases is 4%.
Right. So the Chancery reversals is even a fraction of that. So I'm just kind of curious what the dynamic is like when you can't help but to reverse a decision coming out of Chancery. I take it that's not something you do lightly, and does it create some level of awkwardness, or I'm just kind of curious what your perspective is on that.
That's funny, because Leo and I have always debated which of us has been reversed the most. We've never really added it up, but it's probably a product of number of years served on Chancery. I was only there 6, and I think I've been reversed at least as many times as he has in, 15 years or longer, whatever. I think my experience with the Supreme Court with whom I served was there was a close look at everything, but a discussion about what would the impact be on the business of Delaware and the reputation of the court, and how bound are we by the facts that were found by the court below, because we're not substituting our judgment for the fact finding of the chancellor or vice chancellor. Then the next issue became what law applies. If we could agree on that, we would talk about what the potential impact of that law and how the decision should be written, and try to write it in such a way that it's respectful. Every once in a while, the dog gets out of the kennel, but we tried to write the opinion in a way that it was respectful of the court's opinion, trial court's opinion, whether we agree with it or not at the end of the day. I think everybody that I've served with on both courts is very respectful of the other court, has been. And that's 25 years experience on the bench, and 27 years as a lawyer. So,
Leo, did you have anything?
I mean, I just think it's inevitable that when people invest a lot of time and effort in something, and then someone has the last word, that it can, great. I think some of the worst, actually, situations have been affirmances. I mean, nothing was more disrespectful than the affirmance of Chancellor Allen and Time Warner. Nothing. And if you read that, I'd rather have a candid reversal that treats somebody respectfully than to have an affirmance that caricatures the work of a trial judge. I think there's also another thing that people forget, that you can affirm a member of a trial court in a particular case and then reverse the work of 7 or 8 prior judges of that court. What I mean is it strands. And so it's very much institutional, because sure, we don't want to reverse this particular judge, but what does that do to the body of case law that judge may have slighted? And that's sort of Chancery. There's a lot of those strains, and where there's a tension there that is sometimes lost, and where you can't help but reverse Chancery in some ways, right? If you're reversing 4 sitting members of Chancery and it's just not their case, and 5 prior members of Chancery to affirm someone on a different ground, you've actually reversed people in that court. And so nobody likes this, but I think we're all supposed to be grown-ups, and you get past it. A friend of mine who's I grew up with, I mean, he's from Delaware, and he's one of the most distinguished corporate law professors. He's never gotten over the fact that a team from Skadden took apart one of his articles when he testified as an expert. And I told him, you went and came in the court as an expert. And he's like, but you wrote about my thing, and you credited him. I'm like, well, I was a judge in the case. And people were calling other people names, and what does it say in 48 hours that the lawyers did the calculations and showed it was wrong, And it says, so I think we all have to get a thick enough skin. I think there's sometimes a bit of a bruise, right, Chief, for a little bit of time, but institutionally, you have to do the right thing. I think the court tries, in general, there are failures, but tries to be respectful, and I think it's a joint duty of the courts and all to talk about things, and it's not always the Supreme Court's fault if there are more issues that are raised. What I mean by that is, it's also, if trial courts stick to the issues that the parties raise more, stick more to tradition, leave the law innovation to the parties to raise, then I think it becomes more predictable for everybody. I think it's when there's more of a dynamic process that may not be coming up in the traditional way, where there's a rub between precedent and the trial court ruling, and you get more of those at one time when there's more of you can call it dynamism, but with the dynamism bill, the tension obviously can arise. That's part of what explains the takeover tension in the 80s, right, Myron? There's a dynamism going on between Chancery and the Supreme Court over the whole idea of how can you use a pill, all that kind of stuff. And, you can get some institutional friction out of it. I think Delaware has always tried to rise above that in the long run. But to say that anybody likes to get reversed, I mean, I think it's like saying, did anybody like to lose a game? No. I mean, if you care about it, and our trial judges care about what they do, they take it seriously, that getting reversed, sure, it has a little bit of a sting.
It's the RPG that comes out of nowhere that troubles you when you're reversed. I'm thinking of my Malone case where
Yes.
Right.
disclosed it when you wanted the stockholders to vote, but there was no common law disclosure before that.
Right.
But suddenly, in reversing me, we have the common law disclosure, and every case I've cited says the opposite, that the Supreme Court changed the law.
I think of appraisal in that realm too, because there were a couple of significant reversals and interesting opinions. DFC and Dell are the ones that I had in mind, and obviously I think those cases signaled a direction from the Supreme Court to take appraisal back to maybe where it had been at some point way in the past.
Well, no, and that's in my mind, because, one of those reversals could not be of a person that I have more respect for. But I did very much view that, and I think we did, is there was a transition, there's a bunch of cases in Chancery about, how you look at a third party kind of situation and appraisal. And there's a choice you make, right? I mean, what I'm saying is sometimes there are choices because the law is dynamic and because there are strands, where it's not as simple as we can affirm without it having an implication for other judges on the court and other doctrine of the court. And that's when, again, I think we all have to realize that it's a larger system than any one of us, but none of us I like to think, and I know that the three of us, none of us like to reverse any colleague. And the hardest is actually sometimes when you end up reversing some of the people that you have the most respect for, but that's kind of what you sign up for at each level. And I think that the larger system over time works because people recognize that that's their duty.
Yeah.
And
Yeah, and as I've just explained, I'd forgotten all about Malone. I've gotten over it years ago.
Craig, did you want to take one?
I just want to follow up, though, but we've talked about friction and tension that can just happen because of the nature of the job, but are there particular ways that you manage that? these courts need to work together in a way, and how do you manage the inevitable friction that comes out of being or overruling your colleagues, your friends?
Well, first of all, it's, as Leo and Myron said, it's uncomfortable. It's always uncomfortable, but that's what we signed up to do on the appellate court, is to take a fresh look at things. I know it's torture for trial court judges to watch the tapes of Supreme Court arguments. I have no idea why they want to do that, because 9 times out of 10, it's a different case being argued that they saw in front of them. At least that's usually the playback of the oral arguments. And the lawyers, too, they're creative. They figure out how to mold their arguments for the appellate court. Look, I take the Ruth Bader Ginsburg approach to reversal, which is, I'm sorry, I tried to do the best I could. We are imperfect at times. We all try and do the best we could, and we thought that that was the best thing to do under the circumstances. And that's all I can really say. And it's just so important, as Leo and Myron said, to be respectful. I am a big defer to a court making factual findings. I think that would probably be the most annoying basis to be reversed, is to say that the factual findings of the trial court are clearly erroneous. I can't think of a time, at least in a majority opinion, where that has happened.
Well, I think the other thing, Chief, that the three of us really did, Corinne, too, is I think the three of us really were very careful about not considering issues not properly raised below. But I'll tell you what's also awkward, and this is a sort of a discussion, is if the parties come up to you on appeal and the issue as framed before us has no rational relationship to what they both argued, and we've experienced that, because the trial court has transmogrified the case, then that puts us all in an awkward decision. So I think part of it, and part of it is communication, but I mean, it's all being disciplined, going back to people in chancery in particular. It's one thing in like a criminal appeal, right, Myron, where you might fear that somebody's going to spend time in prison because an issue isn't raised. When you're talking about well-heeled parties in chancery, if both the trial court level and the appellate court level kind of hew to what was raised below, unless there's a candid reason to go otherwise, and you invoke the limited exception, then that works really well. And so I think I think there are many times I see someone here who argued to us in a case where he won on appeal, and a lot of it was on. My friends may have a good argument, but this is not what the case was about. And I think hewing to that is also a way, Corinne, that helps the trial courts. But it also, again, there's that reciprocal, the trial court then itself hewing to those things. I think the other thing is we do communicate a lot traditionally outside things. And when the Chief's saying that he's working with the Chancellor on the 111 issues, the other thing that is payback, and I know that Chief Justice Steele, when I was Chancellor, did this, and I know other Chief Justice Veazey did, is you're working together a lot to support the system. And a lot of times the Supreme Court is working very hard to get the Court of Chancery or the Superior Court the resources that they need. And so on a lot of other levels that are very human, it helps kind of put this reversal issue a little bit in perspective.
So I know I think we're out of time, but I am gonna ask one more question, Louisa, and it's if you all, and you have to keep your answers tight because we're on a schedule, but if you had a crystal ball and you were looking ahead over the next 12 to 18 months, what do you see coming down the pike as the most either important sort of issues on the horizon or things that need to get kind of clarified in our corporate law? I know that's maybe not the easiest question, but if you had to pick an issue, what do you think you put up at the top?
Myron?
And I'll take any answer I can get.
Well, I was about to answer until you said about the corporate law. That, for me, the question...
You don't have to limit it to that, then.
Always is the federal government getting out of its lane and concluding for whatever reason that governance standards should be one size fits all and ruled by bureaucrats from Washington. Everything we can do to avoid that, we must do. That's not a precise question of internal Delaware corporate governance law, but that's always been and always will be my fear and worry.
Leo, do you want to go next?
Yeah, I think in corporate law, again, I don't think it's serious. I think it is figuring out whether something that was in, a large measure my creation, whether MFW was a solution to a specific problem or it's a specific problem and it's creating its own problem. And I think that's a dynamic thing. On a more important Delaware front, because we're for the universe, we have a great privilege. This is an amazing state. Many of you don't necessarily even live in the state, but you benefit from it. You live over the border or you came here. I don't believe we can be strong as a corporate law state if we're not strong as a state. And the level of inequality in our state is not acceptable. And it has grown. And it has grown as a time that we have become more prosperous as a bar. And we are supposed to be the people who symbolize justice. And so I think my biggest worry for our state is that we're not living up to our ideals on much more important levels. And that if we don't attend to that and do justice, and we can do that in a way that doesn't require any kind of kid to get bussed anywhere they want, but obey basic equality measures, then it's all going to be hollow and it's going to become a strategic risk. And if you don't listen to the people on the train, and when they come down to our community and how they talk about the fact that Delaware is so prosperous, but they see the inequality right in their face, I think we're really missing the big picture.
CJ, you get the last word.
So I'm kind of back to Jim Soules and civics and public service. It pains me when we have to work so hard to find people to want to join the judiciary. And we work really hard when we have vacancies now, and the ranks are thinning of people who want to do public service. And I don't know what the answer to that is. We're working on civics education in the schools. We've re-envisioned DELREC, the Delaware Law-Related Education Center, to expand their mission into civics education in the schools, and we're doing that in partnership with the University of Delaware. But I worry that people are very comfortable in their law firms right now, but aren't willing to step forward when there is a need, like happened in the past. The other thing that worries me very much is what the corporate law and the forum for adjudicating disputes is going to look like in 10 years. Technology is outpacing everything that we're talking about today. I mean, AI is writing legal briefs. AI is being used in discovery. AI is going to be used in decision-making. And if we don't continue to operate at the speed of business, as the expression goes, we're going to get left behind. So we need almost an office of innovation for our court system, which is going to anticipate and keep up with these technological trends, because 10 years from now, we are not going to be doing cases like we're doing them now. It's going to be completely different, in my humble opinion.
Well, with that, I'm going to take my cue and say thank you to this panel. I could sit here all day and ask you more questions. We could get to the really hard ones now, but instead we're going to call it, and thank you all. So.